Good morning, everyone. We've had the first rush of people joining, and we've hit the magic number of, I think, more than 150 now. So let's make a start. Welcome to the next installment of the King's Chambers Professional Negligence webinar series. To introduce ourselves to those of you who don't know us, my name is Ben Harding. I was called in 2005. I've been at King's since 2008. And I'm joined by my colleague Chelsea Carter, who was called in 2014 and has been at King's since pupillage. We're both part of the business and property team at King's Chambers, and we both have specialisms in professional negligence work. And indeed, Chelsea and I used to sit at the same group of desks in Chambers in the days when that was a thing. Today, our topic is accrual, Section 14A and Section 32(1)B of the Litigation Act 1980. And those sections, you'll no doubt all know, refer to extensions of time in the case of latent damage and postponement of the cause of action in the case of deliberate concealment. We've chosen this topic because we find that it's not uncommon in prof neg cases for a claimant to have no idea that something's gone wrong with a professional service or advice they've received until many years later when they try to sell an asset or enforce a contract or whatever it may be, and they find out that what they've got isn't what they thought. It's worth less, it's maybe literally worthless, or it's going to be more expensive to enforce. And the question, that goes with the territory really of prof neg cases, because clients engage professionals to do a job properly, and they, particularly in cases where the allegation is the professional failed to do something, there's really no reason for the client to know that the professional's not done the thing or to second guess what they've done. So limitation questions, certainly in my experience, loom very large in prof neg cases, and that's often the first thing you have to deal with. And it's often the first thing the defendant or their insurer are going to raise, and they will frequently not even talk about the rest of the case until limitation has been dealt with. So we thought it would be useful to do a session where we talk about three of the main ways you get round obvious limitation problems, both to give some guidance on what the lay of the land is, but also some pointers as to the sort of things that you're going to need to be looking at to work out, if you're for a claimant, how good their prospects are of showing the claim's been brought in time, or if you're a defendant, how good are your prospects of shooting down a claimant's case on limitation. I'm going to be talking about accrual of cause of action and Section 14A. Chelsea will be talking about Section 32(1)B and deliberate concealment. We're going to talk for a total of about 40 minutes. There should be a few minutes for questions after we finish speaking. We'll take the questions by looking at the chat function for questions people have put there, or if you want to virtually raise your hand, we should see that as well and be able to go from that. We are going to circulate afterwards the slides that we've prepared, so don't worry about trying to note down case names or anything like that. I should also inform you all the seminar is going to be recorded, both so that a recording is available on our website later, but also so you're aware that your participation is recorded if you ask a question. That's not a threat, that's not a discouragement, it's just so that you're aware this session is recorded. Okay, so I'm going to move on to start talking about accruals of cause of action. And the way we're going to do it is by screen sharing the slides that we've got. So I will start my screen share now, starting with the basics. And I'm going to canter through this because I appreciate that most, if not all of you, will already know the majority of this. Primary limitation period that we're talking about, and I'm really going to focus on contract and prof neg and negligence, because that's really what tends to be your cause of action in prof neg cases. 6 years from date of accrual in tort and simple contract. If you happen to have a misrepresentation claim thrown in there, which sometimes happens, that's an action founded on tort, 6 years again under Section 2. Worth checking, because it does occasionally happen, that the contract is actually in the form of a deed, particularly if you're in the construction context where the construction professionals may give a deed in relation to their services, in which case you've got 12 years from the breach of contract and limitation may not be a problem at all. That's probably all I'm going to say about construction cases, I should say, because that's really its own little world because of the kind of issues that arise in terms of when damage is suffered in relation to construction projects. But a lot of what I say would be applicable in principle to construction cases as well. I'm also not really going to talk about breach of fiduciary duty and some of the other niche areas, because I think our focus is most usefully on the causes of action that are definitely going to be there. Another important point on the basics is pleading and proof. The general rule, as we all know, is that a claimant doesn't have to prove their claim is brought in time straight out of the gate. If the defendant raises limitation, then the burden is on the claimant to show that the claim was brought in time. There is a slight wrinkle to that in the context of Section 14A I'm going to come back to. Now, under the CPR, the defendant is obliged to give particulars of the expiry of any limitation period relied upon. But in my view, the defendant failing to do that doesn't mean that the defendant hasn't raised limitation at all. If they just literally plead limitation, I think that's enough to put the burden on the claimant. It's also worth remembering that the defendant can always prove an earlier date of accrual if they want to. But if they want to do that, then it seems to me they're going to have to prove the facts that they rely upon as giving rise to that earlier limitation date. Okay, so I want to look at contract briefly and then tort in a little more detail. And really the three things that I'm going to be thinking of in terms of the kind of arguments you might want to raise to get around a limitation problem are continuing duty arguments, contingent liability arguments, and arguments that loss wasn't really suffered at the time of the original advice or work, or whatever the case may be. Contract. The contractual prof neg claim often isn't really in the picture for the simple reason that the cause of action accrues when the contract is breached. And that very often is back when the negligent work was done, and that can accrue whether or not any damage at all was suffered at the time. To get around this, it is sometimes argued, and this applies both for contract and tort, that the professional owed some sort of continuing obligation after the initial work was done. And this is a tempting argument to run, particularly in cases where there is something that the professional could easily have done to make good the problem. So it's very tempting then to say, well, the problem could have been solved up until date X, and therefore you had a continuing obligation to review, and you could have done something about it up until date X. Therefore, I could bring a claim up until 6 years from that latest date of that period of time. And this has worked on occasion in cases. And the example I've cited there is a case of Midland Bank Trust and Het Stubbs and Kemp, which is quite well known. But in that case, it was held that a family solicitor had a continuing duty to take steps to register a 10-year option to purchase a farm, even in the period after this deed had been executed. And therefore, the claim could have been brought until the expiry of that 10-year period. But in general, continuing duty arguments are hard to run. And the general thrust of the case law is to the effect that the professional is not, generally speaking, going to owe a continuing obligation, and really you need special facts to establish that that is the case, so as to enable you to say that there's another cause of action that accrues later. So showing that there is an ongoing retainer is a starting point. So if you've got a case where advice is given or services are provided during the course of a year-long or a yearly renewing contract, that might be a start. But even then, it's been held, and this is the Capita case mentioned in the slide, that there's no duty during an ongoing retainer to go back and look at work that's previously been done to see if there's a mistake. Might be different if there's reason to think that there was a mistake, or if the client asks the professional to review the earlier advice. And I've also cited the Bell and Peter Brown case, which is really the leading case for the point that, generally speaking, the professional's not going to owe a continuing duty. And once the work is done back at the time, that's likely to be when your breach has occurred, and not at the later date when problems arise. Tort, moving on to that, two issues arise here that are of particular interest. The first is when the damage is suffered. Is it at the time the work is done, or can it be argued to be later? And the second is contingent liability. Can it be argued that the claimant hasn't actually suffered damage in the required sense until the problem that they're exposed to actually happens? In general, the tort cause of action accrues when the claimant suffers actionable or actual damage, which has been described as any detriment, liability, or loss capable of assessment in money terms, and it includes liabilities which may arise on a contingency. A couple of points arising from that. The damage does have to be something which is recoverable in law. So if the damage that is suffered when the work is done is something that isn't recoverable, time doesn't start running. So pure economic loss in the case of tort claims. It is also worth noting that depending on your facts, it may be enough for time to start running that the customer has received something different to what they wanted, even if it's not necessarily less valuable or the difference can't be measured in money terms. So the Shaw and Sedgwick Financial Services Limited case I've mentioned there, time started running where the claimant became committed to a higher risk investment than they wanted, when it was one that could actually be better performing than the one they wanted, but it wasn't what the customer wanted. I've put a possible line of argument there about, well, what if you have multiple pieces of work or multiple instances of loss? Can you argue that the cause of action accrues at a later date, when a later piece of advice is done and or when a later instance of loss occurs? These cases are pretty complicated, but as a very general rule of thumb, what I would say is where there are multiple instances of loss, that's unlikely to help you if that loss ultimately flows from the same original breach, because you don't get a fresh cause of action when you suffer a further round of damage caused by the same piece of negligence. In terms of multiple pieces of work, that's more promising. If there genuinely are different pieces of work done, then you may have separate causes of action, but you may have a causation problem if the loss that's been suffered was actually originally suffered as a result of the earlier piece of work. It's all very fact specific in terms of what the connection is between the later work and the later loss and the original breach of duty. And the case I mentioned just now with the definition of damage referred to the possibility of liability on a contingency. This is a topic in itself, and I've tried to encapsulate it here. It's a difficult area in part because what lawyers mean by contingent liability varies, and lawyers use it to mean different things in different contexts. In the prof neg context, it's been said that a contingent liability is a liability which by reason of something done by a person bound may or may not arise depending on the happening of a future event. And the example given in the case I've cited there was the liability of an insurer in respect of an insured event that may occur in future. So that's a clear example because one can see that at the time the insurer provides insurance cover, they don't have a liability to pay any claims, but they have agreed to a contract under which, depending on what happens, they may have a liability to pay certain claims. That is a genuinely contingent liability. When that's translated to the context of tort and limitation, what sometimes happens is that claimants want to argue that the loss they've suffered is actually a genuinely contingent liability and that their cause of action isn't going to accrue and time's not going to start running until the later date when that contingency actually happens. And as a very general rule of thumb again, that's hard to establish in practice, and the court is very reluctant to accept arguments that the cause of action accrued later on this sort of basis. I've set out there, and I'm not going to go through them, and you can see them on the slides when they're circulated. I've set out a number of illustrations of this principle and examples of where the court has held no actual damage occurred back at the time the work was done or around then at the time the work was done or when the customer enters into the contract or acquires the asset in question, and not at the later date when the customer tries to do something and then they can't do what they wanted to. One example which I found particularly helpful on this was the third bullet point, an unenforceable restrictive covenant in an employment contract. Actual damage is suffered when the employer enters into the covenant with the employee, and they, because they've got something less valuable at that time, they've got a contractual right as against that employee that's not worth what they thought it was. The cause of action accrues then and not at the later date when they try to enforce. I would also, because I think this is the sort of thing that comes up in our practices as a subject matter, the last bullet point, negligent litigation, the damage is suffered at the point when there is a serious risk that the claim can be struck out as the result of the negligence, not at the later point when the claim is in fact struck out. Indeed, there are a few cases where the contingency argument has really succeeded. I've referred there to the Law Society and Sefton case, which is really the leading case on that point. And it's a pretty unusual case on its facts, which there isn't really time in this session to go into in a lot of detail. But there, the liability in question was a genuinely contingent liability because it depended on whether or not clients of a solicitor's firm would make claims against the Solicitor's Compensation Fund in future, and whether the Solicitor's Compensation Fund would accept those claims. So one can see why that's more in the realms of an insurer and contingent liabilities under an insurance policy than it is the kind of cases I've mentioned in the earlier bullet points, where one can see they haven't got what they thought they were getting, or they've got something less valuable than they thought. So much for accrual of cause of action. Now, you may take away from that, well, there are arguments you can run, but I'm pretty skeptical about whether they would work. But there are glimmers of hope in there if you've got an apparently time-barred claim. And it's always worth looking at accrual, otherwise there's a risk you're going to miss a trick. So it is worth investigating and worth at least ticking off those possibilities to see that they don't work in your case, or maybe they will. Moving on to the more promising area from our point of view today, Section 14A. And the problem of latent damage. And as we will recall from law school, no doubt, Sections 14A and B were introduced into the Limitation Act to deal with the problem of a claimant not being aware of a breach and not even being aware they'd suffered damage, but their cause of action possibly already having become time-barred because of the way that accrual in tort and contract work. And the solution to this was to introduce an extended time period in cases where the claimant lacks certain knowledge, and it can postpone the time running to a later date, so we're going to come to see. But that had to be balanced against the need to avoid the unfairness to defendants of being faced with very old claims and the general undesirability of the court system being gummed up with stale claims. So Section 14A, the solution here, it only applies to the tort of negligence. That includes negligent misstatement if that happens to arise on your facts, but it doesn't include other types of things that you might call negligence or are colloquially called negligence. So negligent misrepresentation under Section 2.1 Misrepresentation Act, that's not included. Contractual duties of care and skill, that's not within the scope of Section 14A. And similarly, the duties of reasonable care under the FCA handbook, if you're talking about finance professionals or insurance professionals, those aren't within Section 14A. It's also important to note, and it rarely comes up in my practice, but if the claim includes damages for personal injury, there's a separate regime under the Limitation Act for that. So where Section 14A applies, the broad effect is that rather than 6 years running from the accrual of the cause of action, you have a dual limitation period, 6 years from the accrual of cause of action, or 3 years from the starting date, if that 3-year period is going to expire later. The starting date is the earliest date on which the plaintiff or any person in whom the cause of action was vested before him first had both the knowledge required for bringing an action in damages in respect of the relevant damage and a right to bring such action. Put aside the right to bring such an action, you've got to check that, but that's usually straightforward. What is the knowledge required for bringing an action? That's a defined term rather than left at large, and it means knowledge both of the material facts about the damage in respect of which damages are claimed and of the other facts relevant to the current action, as are mentioned in a later subsection of Section 14A. So there's two things. You need to know material facts about the damage and certain other listed facts. The material facts about the damage basically go to the severity of the loss. Is it a serious enough loss or damage that somebody would investigate it if they thought it wasn't going to be defended? Then separately, and this is the third bullet point I've got, these are the facts relevant to the action mentioned in subsection 8. The damage was attributable to the act or omission, the identity of the defendant, and the reasons why this defendant is being sued if the act or omission was by someone else. I'm going to put aside the ones about the identity of the defendant and about the basis for pursuing this defendant when it's someone else's act or omission. The key ones we want to focus on are the damage being attributable. And you need to have both these elements, because you can have a claimant who knows that they've suffered sufficiently serious loss and damage, but not that it's got anything to do with the defendant. And you can have a claimant that knows that there's been something wrong in the advice, but they don't know that they've suffered loss as a result. I set out in this slide some pointers which I hope will be useful in how you investigate with a client whether or not they are likely to have had the actual knowledge required for time to start running. Because there's a lot of different parts to Section 14A, and there's a lot of case law about what degree of knowledge you need to have, what degree of certainty there needs to be before you're held to have actual knowledge. Because, and to start with the last bullet point here first, the question whether or not the things the claimant knew included that it amounted to negligence as a matter of law, that's not relevant. It's all about the facts that the claimant knew. So in terms of degree of certainty, the claimant doesn't need to know for certain, but they need to have enough knowledge to justify embarking on the preliminaries to issue a writ. So writing to the proposed defendant, taking legal and other advice. So as a rule of thumb, that means suspicion's probably not going to be enough, but reasonable belief that there's been damage suffered, that is likely to be enough, and you need to explore that. So if you've got a client that says, well, I knew something was wrong, I knew there was a problem, that's going to be your starting point. And they may say, well, I didn't know for sure, but they don't need to know for sure. Then in terms of the level of detail, they might know some things certainly, but they might not know in detail what actually went wrong, or in detail what the defendant did or didn't do. One doesn't need to know the full level of detail that the lawyers would put in a claim, but one does need to have broad knowledge of the essence of the complaint. And finally, here, the causation element. There has to be some linkage between the damage and the act or omission of the defendant. And what's required here is not that the claimant knows that it was a but-for cause or a balance of probabilities cause. They need to know that the act or omission is at least a possible and not fanciful cause of the damage. But you also have to look into what other causes the claimant may have thought there was, because if the claimant confidently believed it was some other cause, they may not have sufficient knowledge to think that it was the act or omission of this particular defendant that the damage was attributable to. There are certain ways in which knowledge is extended. So actual knowledge may include, or the claimant may be treated as knowing the knowledge of agents and employees, which is important if you've got a corporate claimant. They may also be fixed with the knowledge of other partners if the client is a partnership. It depends on the terms of the Partnership Act. There's also some interesting case law on things like the claimant being fixed with the knowledge that their solicitors had, which will depend on the scope of the retainer and what information the solicitors were obliged to pass on. And also where the claimant has entrusted their affairs to others, they may be treated as having the actual knowledge those people had. And there is also, of course, constructive knowledge, which is the next big topic we need to move on to. This is in some ways the most complicated part of this, and it's the one where it's the most difficult to predict what the court is going to do. So a person is their knowledge is deemed to include knowledge they might reasonably have been expected to acquire from facts observable or ascertainable by them, or from facts ascertainable by them with the help of appropriate expert advice. And the section finishes with a bit of protection if you try to get expert advice, but you don't. This is, I've set out some analysis here, which I'm not going to go through in detail, but I'd invite you to look at if you've got a constructive knowledge case. It's a largely objective test because of the number of elements of reasonableness and discoverability, ascertainability in the section. Some subjectivity in the sense that it is what the claimant would be expected to acquire, the knowledge the claimant would reasonably be expected to acquire. So the court takes account of the claimant's general characteristics, but not their peculiar features. And this is similar to Section 32. And I would draw your attention, I think, particularly to one of the cases I've mentioned in the first set of bullet points there, setting out the cases about discoverability, etc. This is the Finance for Mortgages Limited case in Farley & Co., which is an illustration that the court is really prepared to go a long way into a hypothetical alternative world to find that the claimant could have found out something that they didn't in fact find out till later. In that case, the court said a lender who could see that there were problems with their borrower should have taken possession proceedings, they should have repossessed, and then they should have obtained a retrospective valuation within 6 weeks of repossession, and therefore they should be fixed with constructive knowledge of what they would have known had they taken all of those steps. It seems to me that that is going a long way away from the facts that lender knew, but it just goes to show that as a claimant, you are vulnerable to potentially quite detailed hypothetical accounts of what you should have done. Right. I've dealt in that slide with the wrinkle I mentioned too in terms of burden of proof. There is some suggestion briefly in the case law that on constructive knowledge, the burden is on a defendant to show that the claimant had constructive knowledge earlier. I think that may be limited to personal injury cases, or it may not be what the case really says, but it's something to be alive to. And it may mean that as a claimant, you can throw that back at the defendant if they're asserting that you had constructive knowledge sooner. And finally, for my section, don't forget the long stop. Section 14B gives a 15-year long stop, and that 15 years runs from the act or omission. It doesn't run from the accrual of the cause of action. So one of the first things you should do in a case involving genuinely old breaches is check that it's not more than 15 years ago, because you can waste a lot of time investigating constructive knowledge, but then find out that actually you're going to fall foul of the 15-year long stop. If you do, the only thing that is likely to rescue you is deliberate concealment, because where section 32 applies, sections 14A and 14B don't. And I've addressed that in the final slide in my section. Anyway, I'm now going to hand over to Chelsea to deal with deliberate concealment, which is going to be your next port of call. I'm going to stop my screen share and Chelsea will start hers.
Brilliant. Thank you, Ben. Good morning, everyone. My name's Chelsea and I work alongside Ben in the business and property team. As Ben has already stated, I'm going to be dealing with section 32(1)(b) of the Limitation Act. That relates specifically to deliberate concealment. Now, I have reproduced section 32(1) on the slide because I think it's important just to have a look at that first before I jump into the specifics. Because this section actually covers the cases of fraud, deliberate concealment and mistake. So just make a note of that at the outset. I'm going to be dealing with deliberate concealment, though, in section 32(1)(b). Now, we can see here, of course, it states that subject to subsections 3, 4A and 4B, where in the case of any action which period of limitation is prescribed by this Act, either any fact relevant to the plaintiff's right of action has been deliberately concealed from him by the defendant, the period of limitation shall not begin to run until the plaintiff has discovered the fraud, concealment or mistake, or could with reasonable diligence have discovered it. And you'll note at the bottom of that section, it refers to the fact that it relates to a defendant's agent as well. So that's important to note. Now, I have underlined the relevant wording within the section that would need to be dealt with. So you can see I've underlined the relevant fact, I've underlined deliberate concealment, and I've underlined reasonable diligence. And those are the terms that I'm going to be talking to you about today. So we'll start with the fact relevant to the claimant's right of action. I think it's just very important to note this is the starting point. Everybody likes to jump to the more interesting parts of these cases, deliberate concealment, arguing about fraud, etc. Don't forget to double check that you are dealing with a relevant fact. Now, in Jonstable and Chief Constable of Surrey, it was held that the phrase fact relevant to the claimant's right of action meant a fact without which the cause of action would be incomplete. Now, it's not relevant that the defendant has concealed a fact which, if known, would merely strengthen an existing case. This is sometimes referred to as the statement of claim test. So the question is whether the claimant already knows, actually or constructively, facts which by themselves would enable them to produce an adequate statement of case. And if so, then time runs against them, even if there are other facts which would help their case and of which they are unaware. Now, this rule was reaffirmed in the Critty Palm. I'm sure, as many of you will know, the Critty Palm was ultimately overruled the main points that we're going to come on to. But it's important just to note that in relation to the fact relevant, it includes a very helpful excerpt at paragraph 307, which states that the purpose of section 32(1)(b) appears to be designed to cater for the case where, because of deliberate concealment, the claimant lacks sufficient information to plead a complete cause of action. So it's therefore important to consider the facts relating to an allegation of deliberate concealment by reference to the particulars of claim. The particulars of claim is always the starting point. Even if, for example, you're dealing with a small claims, which sometimes do deal with these points, please don't ignore them, and please don't think the court will ignore them. Whether it's small claim, fast track, intermediate track, multi-track, the court will go to the particulars of claim. So please bear that in mind. Now, Arcadia Group and Visa actually contains a really helpful summary from the Chancellor at the time in relation to section 32(1)(b) by reference to all of the helpful earlier authorities, two of which, of course, I've touched on. And it states that in Johnson, the Mirror Group newspaper, and the Critty Palm, they are clear authority binding on the court, of course, for the following principles. 1, a fact relevant to the plaintiff's right of action within section 32(1)(b) is a fact without which the cause of action is incomplete. 2, facts which merely improve prospects of success are not facts relevant to the claimant's right of action. And 3, facts bearing on a matter which is not a necessary ingredient of the cause of action, but which may provide a defence, are not facts relevant to the claimant's right of action. So that's just a really helpful summary. And in particular, if you're looking to put forward a skeleton, that's a really helpful summary to include for the judge. Now I'm going to move on to what is the much more interesting and hotly debated part of section 32(1)(b), and that is deliberately concealed. Now, just before I get onto the main case, which I'm sure you're all aware of, I just wanted to touch on these slightly smaller points. Firstly, it's important to note that a mistaken concealment isn't going to fall within this section. If it's just simply a mistake and they haven't put forward the information, that's not going to cut it. I've referenced a relevant case there if you need it. This doesn't really happen very often. I'm not sure I've actually dealt with a case where mistaken concealment has popped up, but just bear that in mind if you are dealing with another party that says, look, I didn't even know, because they will then be falling back on this mistaken concealment point. Now, I've also referenced misrepresentation. I've referred to an older case of Lynn and Baber. In that case, it was about trees. I think it was plum trees. The defendant sold the plum trees to the claimant, falsely stating that they were of really high quality. The court held that, assuming the fraud to be proved, the claimant could have relied upon either simple fraud or fraudulent concealment within their claim, i.e. they can rely on section 32(1)(b). Now, this proposition isn't contentious, but this does appear to be the only case in which it has actually been held that section 32(1)(b) is applicable in cases of straightforward misrepresentation. It's not usually something that people rely on in misrepresentation claims, and as far as I can see, this is the only case in which it has been relied on. So I've noted it, but it's exceptionally rare to the point where there's only one case. We've then got reference to concealment by an agent. I noted when we were looking at the actual contents of section 32(1)(b) that it actually deals with the concealment by a defendant's agent as well as the defendant themselves. And in the case of Archer and Moss, the defendant was the developer of the land, while the fraudulent concealment was actually perpetrated by the builder. Now, the court held in that case that the developer was liable, since the builder was to be regarded as its agent for that purpose. Now, again, this is very specific on the facts, so I'm not saying it's a general principle that you'll be able to apply, but I think if you are especially dealing in the construction sphere, it's important to note that there are a couple of cases in this regard that deal with specific facts. So always have a look and see if they apply, whether directly or by analogy. So that was Archer and Moss. We then had a subsequent case of King and Victor Parsons Co. That was a case in the Court of Appeal, and actually 2 members of the bench had also participated in Archer and Moss. That case was concerned with houses that had been built on the site of an old filled-in chalk pit. And in that case, the defendants were the estate agents who had acted for the builders. And it was held that they were themselves liable to the claimants who had purchased houses on the site, as they, as the estate agents, had had actual knowledge of the existence of the chalk pit. Now, I stress the word actual knowledge because as far as I can see, we don't have any sort of really pointed authority in relation to constructive knowledge. So you might have to be rather clever if you're going to be relying on some of these cases in relation to constructive knowledge as opposed to actual knowledge. Now, that brings me on to the main thrust and the main case under section 32(1)(b) in relation to deliberate concealment. And it effectively deals with silence as concealment, if I can put it that way. That is the case of Canada Square Operations and Potter. It is a Supreme Court case from a couple of years ago. Now, I'm just going to briefly run through the facts. You'll be happy to know that they're quite brief, they're quite simple, but they are important for the purpose of dealing with the wording of deliberate concealment. So it was back in 2006 that Mrs. Potter entered into a credit agreement with Canada Square. It was a credit agreement within the meaning of the Consumer Credit Act 1974. Now, Mrs. Potter borrowed approximately £20,000. It comprised of a cash loan of about £16,000 and a PPI premium of approximately £4,000. Now, unbeknownst to Mrs. Potter, over 95% of the PPI premium was actually paid to Canada Square as commission on the sale of the policy. And the insurer themselves, who was actually covering Mrs. Potter, they were only paid £182.50. Now, Canada Square didn't tell Mrs. Potter about the commission. The agreement itself lasted approximately 4 years and it ended in March 2010. Now, roll on 8 years, December 2018, Mrs. Potter issues a claim against Canada Square seeking to recover the commission payments in respect of the PPI policy, plus, of course, what by that point in time is very significant interest. Now, Mrs. Potter claimed that Canada Square's failure to disclose the substantial commission charged on the PPI policy rendered the relationship between them unfair within the meaning of section 140A of the Consumer Credit Act. Now, you will probably already know that sections 140A to 140C of the Consumer Credit Act, they deal with what we regularly term the unjust relationship, unfair relationship jurisdiction. Now, Canada Square argued that it was too late for Mrs. Potter to bring her claim because Section 9 of the Limitation Act imposed a 6-year limitation period, which had expired long ago. Mrs. Potter relied on Section 32 and contended that her claim was not time-barred because the limitation period did not start to run until she had found out about the commission, being both the existence of it and the amount of it after taking legal advice in November 2018. Now, the county courts originally at first instance held that Section 32 applied. They found for Mrs. Potter. Now, Canada Square appealed to the High Court. The High Court agreed with the County Court. Canada Square again appealed to the Court of Appeal. The Court of Appeal agreed with the County Court and the High Court. The Court of Appeal, of course, gave permission to appeal. We went to the Supreme Court. Now, the Supreme Court was specifically asked to clarify the meanings of the words deliberately and concealed on a separate basis, not together. So if you do have an opportunity to read this judgment and you are dealing with this area of law, I don't always recommend trawling through long judgments, but this is an important one. So if you do actually have the time and it's something that you are dealing with, I suggest you do read the whole judgment. But I have referenced some of the more significant paragraphs for you if you just want to jump to the specific paragraphs that deal with this discussion of concealed and deliberate. So we'll first deal with concealed. And the court found that a fact will have been concealed if the defendant has kept it secret from the claimant, either by taking active steps to hide it or by failing to disclose it. So either active steps or a passive failing. Now, contrary to previous Court of Appeal authority, the claimant does not need to establish that the defendant was under a legal, moral, or social duty to disclose the fact, nor does she need to show that the defendant knew the fact was relevant to the claimant's right of action. All that is required is that the defendant deliberately ensures that the claimant does not know about the fact in question and so cannot bring proceedings within the ordinary time limit. Now, the Limitation Act doesn't draw a binary distinction between cases involving active concealment and cases of non-disclosure, so we'll call it passive concealment. Now, a plain reading of the section the Supreme Court held encompasses both the positive steps and the passive non-disclosure. So a simple example would be if a builder knowingly conceals for the purchaser of a house the fact that the foundations are defective, either by positive steps, so say such as by physically covering up the bad work so that there was no opportunity for examination, or by a passive non-disclosure, such as by simply failing to tell the purchaser about the problem, that would constitute the deliberate concealment of a fact which is relevant to the claimant's right of action against the builder. Now, the Supreme Court gave some rather strange examples, but I think it is interesting just to go there. I gave the builder example because I think that's a bit more, it's easier to follow. But I think it is important to point out what the Supreme Court actually stated. And they stated that a person who hides something can properly be described as concealing it, whether there is an obligation to disclose it or not. For example, an elderly lady who was afraid of burglars might conceal her pearls before going to bed, without any implication that she was obliged to leave them lying in plain sight. The next example was some people use cosmetics, concealer, to conceal blemishes in their skin, but again, without any implication that they are under an obligation to reveal the imperfections. The position seems to me to be the same where concealment takes the form of withholding of information with the intention of keeping it secret. So, for example, someone who decides not to tell anyone that he has been diagnosed with an illness can properly be described as concealing their illness without any implication that they are under an obligation to share the information. So it is to be noted that in all the examples that the court gave, concealment involves an intentional hiding or withholding of information, and those two cases are to be treated in the same way. Now, of course, if the defendant actually is subject to a duty of disclosure, whether that be a legal duty, a regulatory duty, etc., then it is possible, and probably more than possible, that that is relevant to the claim. It's definitely a relevant circumstance, because if they were under a duty to disclose and they didn't, I think it's much easier to prove on the facts that we have had concealment here. But that isn't the long and short of it. There doesn't have to be a duty for there to be a concealment. And of course, in Canada Square and Potter, specifically Section 140A of the Consumer Credit Act doesn't impose a duty of disclosure on the defendant. So all of these banks, all of the finance houses back in the day, they were not under a duty, whether legal or regulatory, to actually disclose any commission that they were earning. So in their minds, they were doing nothing wrong as long as they were complying with the relevant guidance, regulations and law. Now, moving on to deliberately, it was dealt with separately. Now, the Supreme Court held that the defendant's concealment of a relevant fact will be deliberate if the defendant intended to conceal the fact in question. The court rejects the Court of Appeal's finding that deliberately can also mean recklessly in this context. Now, deliberate concealment for Section 32 1B purposes may be brought about by an act or an omission, but in either case, the result of the act or omission must be an intended result. There has to be an intention there. Now, the defendant must have considered whether or not to inform the claimant of the relevant fact and then gone on to decided not to. So it's a conscious choice not to disclose, an intended choice not to disclose. And if the defendant has concealed a fact from the claimant and has done so deliberately, that is to say knowingly, and then he has the means to start the limitation period running by disclosing that fact. So say, for example, in Canada Square, if Canada Square hadn't originally disclosed the commission, but say a year later decided to disclose it, at that point they would have started the limitation period from running. If the defendant chooses not to, and they choose to keep the claimant in ignorance of that fact, which they are required to know in order to plead their claim, then it's just that the defendant should be deprived of a limitation defence. And if the defendant isn't sued earlier, they only effectively have themselves to blame because they have made a conscious choice not to disclose. Now, Section 109 of Canada Square and Potter just contains a really helpful summary, and that is to say that what is required is 1, a fact relevant to the claimant's right of action, 2, the concealment of that fact from her by the defendant, either by a positive act of concealment or by a withholding of the relevant information, and 3, an intention on the part of the defendant to conceal the fact or facts in question. Now, applying all of that to the actual facts of Canada Square and Potter, the existence and amount of Canada Square's commission on the PPI policy were facts which were relevant to Mrs. Potter's right of action under the unfair relationship jurisdiction in Section 140 of the Consumer Credit Act. Since Mrs. Potter couldn't plead her case without knowing them, if she didn't know about the existence of the commission, she certainly couldn't complain about its amount. So it was held that Canada Square deliberately concealed these facts from Mrs. Potter by consciously deciding not to tell her about the commission. And although Section 140A was not in fact in force when Canada Square initially decided not to disclose the commission in 2006, they were still going to be bound because Canada Square continued to withhold the information from Mrs. Potter even after Section 140A was brought into force. Now, technically, Section 140A, it's important to note, came into force. It was brought in 2007, but it only started to take effect in 2008. I think from memory, it's April 2008. But double check that if you're going to use it. So they decided in 2008, again, not to disclose the commission. They made a conscious choice not to. And then Mrs. Potter only actually found out about the existence and the amount of the commission in 2018 when she decided to go along to solicitors, tell them about this credit agreement, and they effectively told her, look, in a lot of these cases and credit agreements, there are significant commissions. We've made inquiries and we've now realised that there was a 95% commission on your PPI policy. Now, in Canada Square and Potter, there was no suggestion by the defendant that with reasonable diligence, Mrs. Potter could have discovered the concealment any earlier. So this authority doesn't deal with that point, which I'm going to come on to. So accordingly, in that case, the requirements of Section 32(1)B were met. Mrs. Potter's claim against Canada Square was not time barred because Section 32(1)B postponed the commencement of the ordinary 6-year limitation period and for bringing her claim until November 2018. So she was in time, she was entitled to bring her claim, and she was entitled to repayments of effectively capital commission payments and interest. Now we're going to move on to the last underlined part of Section 32(1)B, and that is this point of reasonable diligence. Now, in the case of Paragon Finance and Thacker, this is a 1999 case, they helpfully dealt with the burden of proof. And I think it's just helpful to read out paragraph 418 on this point. And that simply states, the question is not whether the claimants should have discovered the fraud sooner, but whether they could, with reasonable diligence, have done so. The burden of proof is on them. They must establish that they could not have discovered the fraud without exceptional measures which they could not reasonably have been expected to take. In this context, the length of the applicable period of limitation is irrelevant. In the course of argument, Lord Justice may observe that reasonable diligence must be measured against some standard, but that the 6-year limitation period did not provide the relevant standard. He suggested that the test was how a person carrying on a business of the relevant kind would act if he had adequate but not unlimited staff and resources and was motivated by a reasonable but not excessive sense of urgency. So the burden of proof is on the claimant. So if the defendant turns around and says, well, actually, the claimant could, with reasonable diligence, have discovered the existence and amount, say we'll go on the commission basis of the commission, and therefore that's the end of the matter, section 32 1B doesn't bite. Now, Hussain and Mukhtar is also a very helpful High Court case from 2016. Along with many other authorities, it agrees that the burden of proof is on the claimant, so it's helpful in that regard. But it's also helpful because it states that the concept of reasonable diligence carries with it a desire to investigate. So these claimants have to have an objective desire to investigate. They can't simply say they sat on their hands, ignored the world around them, ignored everything that was happening, any specific references to this fact that has been concealed. They can't say, we just did nothing. They have to have an objective desire to investigate. Now, this is also a helpful case to state that personal characteristics of the claimant, such as naivety and inexperience in financial matters, are not relevant. You will see it pleaded over and over again in claims made in particular against banks, against financial houses. You will always find the claimant stating, I'm little Mrs. Smith from down the road. I am very naive. I don't know what's going on. I've only ever had a mortgage. I'm not experienced in financial matters. None of that is relevant. It is not a relevant personal characteristic at all. That is not to say that some personal characteristics aren't relevant, but when we get into the realms of words such as naive and inexperienced, that's not enough. One example of where it is enough, I dealt with a case. It was actually a secret commission case, like the case in Canada Square and Potter, where the claimant came along and said, I didn't know about the commission. I didn't know about the amount of the commission. I want all my money back with very significant interest. And actually, it only came out in cross-examination that this same claimant actually worked for another bank, worked for another bank, actually knew all about what had been going on with secret commissions, had actually dealt with commissions at the point in time when all of the banks were receiving them, and had actually moved on to the complaints department and regularly dealt with complaints. So it actually came out that she very much could, with reasonable diligence, have discovered what was going on, the existence of the commission, and probably even the exact to the percentage amount of the commission. She just chose to pretend that she was naive and inexperienced. But the fact that she worked in a bank and was aware of all of this background meant that her personal characteristics actually were very important for the sake of considering the facts. Now, OT computers and Infineon Technologies is also very helpful in relation to reasonable diligence. Again, I don't usually like to just simply read through paragraphs, but these two paragraphs, so 47 and 48, really are quite important, and they're the paragraphs that you would need to be taking the court to if you were addressing the court on reasonable diligence. And it states that although the question what reasonable diligence requires may have to be asked at two distinct stages, one, whether there is anything to put the claimant on notice of a need to investigate, and two, what a reasonably diligent investigation would then reveal, there is a single statutory issue, which is whether the claimant could with reasonable diligence have discovered the concealment. Although some of the cases have spoken in terms of reasonable diligence only being required once the claimant is on notice that there is something to investigate, i.e. the trigger, It is more accurate to say that the requirement of reasonable diligence applies throughout. At the first stage, the claimant must be reasonably attentive so that they become aware or are treated as becoming aware of the things which a reasonably attentive person in their position would learn. At the second stage, they are taken to know those things which a reasonably diligent investigation would then reveal. Both questions are questions of fact and will depend on the evidence. To that extent, an element of uncertainty is inherent in the section. So 2 points here. You will hear people referring all the time to a trigger point. This paragraph is very important. We are not looking for a trigger point. We are not looking for something that means that the claimant at that point in time had to be on notice, had to investigate. As it clearly states, the situation is always there. There's always an ongoing requirement of reasonable diligence. It doesn't just start here because something happened. It starts right at the beginning and it works all the way through. So don't fall into the trap of a trigger point. Secondly, in relation to the last couple of sentences in that paragraph, we are dealing with a question of fact here, and it depends on the evidence. Now, remember, the burden of proof is on the claimant. So if the defendant simply just turns around and says, well, with reasonable diligence, the claimant could have discovered this. If the claimant does not address this point and raises absolutely no evidence on this point, they cannot satisfy the burden on this point. So bear that in mind, because sometimes you do have a silver bullet in that regard if the claimant or their solicitors aren't quite on top of the law in this area and where the burden lies. Because it is easy to say to the judge, regardless of the facts that you may believe exist, what you don't have before you is such evidence from the claimant. The burden is on them. They don't address it. So there we are. That's the long and short of it. Now, paragraph 48 is also very helpful in this regard. It states that while the use of the words could with reasonable diligence make clear that the question is objective, in the same sense, sorry, I'm just moving my face, Abba. So while the use of the words could with reasonable diligence make clear that the question is objective, in the sense that the section is concerned with what the claimant could have learned and not merely with what he did in fact learn, the question remains what the claimant, or in the terminology of the section, the plaintiff, could have learned if he had exercised such reasonable diligence. That must refer to the actual claimant, in this case OTC, and not some hypothetical claimant. So again, this is on the point that it has to be the experience of the claimant themselves. The burden is on them. They have to put forward the factual basis to say that they could not, with reasonable diligence, have discovered the fact relevant to their right of action. In relation to OT computers, permission to appeal was sought and it was eventually refused by the Supreme Court. So this is now standing. It's the authoritative case on the point. So please go to OT Computer straight away if you're dealing with reasonable diligence. Now, that brings me to the end of section 32 1B. So if anybody has any questions at this point, I'm just going to jump on and see if we've got any, or if Ben wants to have a look as well.
I did see one, which I think I appreciate. We've virtually run out of time, and of course, if people have to leave, they have to leave. But there's one I think we should probably pick up on because I think it's a very good question, and we can address in a couple of minutes, I hope. This is a question from Chris Anderson, which picked up on me saying that claimant doesn't need to address limitation, but if the defendant raises it, the burden is then on the claimant. And the question is, does it not make sense for the claimant to address the facts that fit the limitation extension from the outset, so that when the point is raised, you can effectively refer back to the facts you've already pleaded? And it is a very good question. I think there's two parts to the answer. The first is that if you're a claimant, you may be missing a trick if you deliberately plead out the basis on which you're going to say your claim's in time, because there is just possibly a chance that the defendant's not going to raise it. In practice, I've never seen it happen because most professional defendants have insurers, and those insurers will instruct lawyers who are definitely going to raise limitation if it's there to be raised. But the first part of the answer is, well, you if you don't need to deal with it, leave it, because you might just get a windfall if the defendant doesn't address it. The second part of it is that you do, on the other hand, have to carefully plan out in advance what your response to the anticipated limitation defense is going to be, because that's going to shape how you describe your cause of action and how you describe your breaches and your loss. Because if you're trying to deal with a limitation problem, you are going to try as best you can to deploy things like continuing obligations, contingent liabilities and such like. And therefore your particulars of claim needs to fit that. It's no good pleading out your claim, then waiting for the limitation defense and responding there, because you might already have committed yourself to a version of events that's not going to work in the particulars of claim. All I would add to that is that the court is very alert to clever pleading tactics to avoid limitation problems. So if, for example, you try to reframe the duty and say, well, my cause of action accrued later on because there was a duty to tell me about the wrongdoing, and you just leave out the original wrongdoing, the court's going to say, no, the real substance of your claim was a breach of duty back at the time of the original wrongdoing, not a later failure to disclose the wrongdoing. Just as a very general rule of thumb. But no, it's a good question. My view remains, make your facts fit, get your ducks in a row, but don't necessarily say in advance, we are in time because of X, Y, and Z. Chelsea, I don't know if you have any thoughts on that.
No, I certainly agree with everything you've said. I think the only additional point that I would make is the only time I would consider not maybe addressing it head on, and I think Ben said this, is if you don't know what the other party is going to say, but you know it's an issue, maybe wait for the other side to show their hand. So you can address what you need to for the sake of pleadings, but sometimes be very careful not to go too far. You don't want to do the defendant's job for them, and you don't want to raise an issue if you're not 100% sure that they are going to raise that, because, as we all need to remember, limitation is a defence. So that's the only point that I would make. In relation to any other questions, there probably are a few, and if there are any others that I'm not seeing, we will address them when sending out the slides. But I can just see that someone has asked that in relation to presumably the deliberate concealment section, what if the claimant has enough knowledge to ask questions of the defendant, but there's no evidence of what the defendant would, if asked, have answered? And indications as to whether they would have answered correctly or at all. This position does crop up sometimes. So say, for example, just because I am dealing often with secret commissions cases in the context of Canada Square and Potter, there are sometimes situations in which a claimant, for example, will say, well, I didn't go and ask them. And actually, even if I had have asked the defendant, was their commission, what is the amount of the commission, they wouldn't have told me anyway. Now, an assertion like that on its own, in my experience, isn't enough. However, I have dealt with situations where the claimant has made that assertion and then produced an email, for example, to the defendant many years down the line, often only in relation to actually the litigation once they've issued a claim. And there are very stubborn defendants sometimes. So the claimant solicitors will sometimes send an email saying, can you at this stage tell us, now we pleaded the claim, the exact amount of the commission? We pleaded the commission was very high and unfair, but what was the exact amount? And there are circumstances in which the defendant, unfortunately, will turn around and say, we're not telling you that. We're not obliged to tell you that. And if that evidence is before the court, then the court will say, well, probably, realistically, even if the claimant had asked back in the day, it's probably the case that the defendant wouldn't have told them because they're not even telling them now. So that's the only specific situation in which I've dealt with this point, and that's how the court has dealt with it. But I think if you just say they wouldn't answer, that's not enough.
Yeah, I think fundamentally, it, as you were saying in your section, these are questions of fact that have to be decided on the evidence. And the court is going to, if your case as claimant is going to be, I couldn't reasonably have discovered this because if I'd made inquiries, they would have stonewalled me. You need some evidence of that. And if anything, in the cases, I have one at the back of my mind, but in a slightly different context, in the absence of such evidence, the court is more likely to say, well, there's no reason to think they wouldn't have answered the question if you'd asked it. So really, if you're trying to tee up that sort of case as a claimant, you need to focus on what evidence you can get. If you haven't got a specific response from the defendant you're dealing with, I suppose you might be able to rely on evidence that lender in other cases stonewalled people. So do a case search for that lender and see if they've had limitation arguments dealt with against them. That might be a worthwhile source.
Yeah, any evidence, even newspaper articles, anywhere, any evidence is helpful, because where you're dealing with a judge where they're going to have to exercise some discretion, the more evidence they have, the more likely they are to go with you. So any type of evidence you can come across, whether it's direct or indirect. And I think that's probably everything then. I'm sorry if there's something specific. I've got a few messages coming through. I think we've dealt with everything that's a direct question. If not, though, of course, we will deal with anything specific when we're sending out these slides. So you can expect to receive these slides within the next day or so. So thank you very much to everyone for listening. I know we've gone over a bit, so sorry, but hopefully it was all very interesting, and you'll be able to refer back to the slides if you're dealing with cases such as this. So good morning to everyone, and hopefully we'll speak to you soon.
Thanks, everyone. Goodbye.